All right, welcome back to the Lobby Bar podcast. How you doing, Jason?
How you doing, buddy?
Good, good. So, life's been crazy, hasn't it? It's kind
Yeah,
of like
well,
feeling a little bit back to normal. Traffic's back, and it's been kind of wild, huh?
yeah, the traffic is the bad part, I guess, but it's nice getting back to normal, back to the
Yeah,
offices, all the
yeah,
staff back at the offices. It's been nice,
yeah,
feel it. No masks at the stores,
yeah.
getting
Are you
everybody
having a lot of people
vaccinated.
complain about coming back to the office, or everyone pretty happy?
Almost everybody's pretty happy. We only had a few complaints.
Yeah, same here,
Very,
same
very
here.
minimal. I think, at least up here, most people are uh, excited to kind of the uh, the camaraderie's back, having everybody in the
Yeah,
office working
yeah,
together, the assistants and the attorneys, like being able to personally interact instead of be on the chat.
right,
So
right.
it's been nice. It's been nice.
Awesome, awesome. Yeah, it'll be nice when we can kind of like just, have like our normal schedules and, do the conference circuit and get, see clients and do all of that
Yeah,
again,
we're
I think.
we're starting to do that a little bit up here more now.
Yeah.
Some happy hours. I'm
Yeah.
stoked because the golf tournaments up here. There's a few, the Viking AWCP. Those are
Yeah.
happening. So August
Nice.
and October we have those. The conferences are coming back in person this
Yeah.
year, so I don't know. I'm excited to just get it out there again and see people.
Yeah. I wonder how well attended these conferences are going to be for the rest of the year.
I think I think the adjuster circuit up here with the
Hmm.
golf tournaments, and I hope they do the crab feed and stuff. I think those are going to be well attended because I know like everybody
Yeah.
wants to get out now. Everybody's
Yeah. Yeah.
vaccinated. At least
Right.
most people seem to be. Um, I think that the question I think will be the national ones where people are traveling to Vegas, and I don't know where
Right.
National Rims is this year, but um, those will be interesting. I hope they're well attended.
Yeah, it's going to be interesting because I feel like employers know now that just like employees know, like, hey, I could do my job from home. Why are you making
Yeah,
me come in? On the flip side, employers know, hey, you can go to these conferences
yeah,
virtually. I don't have to pay for a hotel and a huge fee for the conference. Why can't these things stay virtual?
yeah. That'll be interesting. Whether or not these employers are going to bring back the travel budgets and stuff like that.
Yeah,
Um, I bet some won't.
yeah,
Or if they've even given it thought since the
yeah.
last year, they probably cut them, restricted travel. Who's brought them
Mhm.
back yet?
Right, right.
That'll be
So,
interesting. But I mean, I hope they're well attended. I hope there's a lot of our industry partners there. I hope we can
yeah,
have some fun again, meet
yeah,
people.
absolutely.
God, I hope so.
I think
you
it'd
know,
be cool to take the podcast on the road and try to like record something at a conference like
there's no
live.
reason we can't. I mean, we have all the
Yeah,
stuff. So,
yeah,
uh, yeah, do it like in a lobby bar.
yeah. Yes, that'd be
Come
awesome.
on, Roy. What was that where you were going for?
Yeah. Uh,
But yeah, then the other big news, I guess, is our firm 10-year anniversary. I noticed that we started kind of planning our 10-year Christmas party. So
yeah,
Vegas,
yeah.
I'm stoked.
It's been 10 years. It should be fun.
Yeah.
Like we haven't gotten together like the whole firm for a few years now. Because after a certain point, like doing the Christmas party all together kind of became a bear to plan and manage. But getting everyone together again, inviting some of our clients, and just having a good
Yeah.
time, I think it'll be fun.
Yeah. Once we hit that point, it got a little unruly, just hard to, with all the
Yeah,
staff and wanting to let people bring a guest and stuff like that. It was hard.
yeah,
So that's when we started splitting them Northern and Southern California parties. But
yeah,
doing the big firm 10-year will be fun. I think everybody's
yeah,
looking forward to get let loose a little bit.
yeah, absolutely.
Yeah. What do you
So,
like other than me? What do you attribute our success to? Do you think?
um,
To
Yeah,
make
man,
it
I don't
10 years.
know.
That's a big milestone,
Yeah,
man. I mean, 10
it
years.
is.
I
It
remember
is.
when we started working together, because I mean, in case people don't know, I didn't start 10 years ago with you. I think I jumped in a year and a half in.
Yeah.
Um, man, 10 years was that felt like a long time, long way
Yeah.
away.
Yeah, it did. It
Yeah.
did. I don't know, man. Like, I feel like we had a good philosophy of how we wanted to handle claims for our clients, kind of tailoring things the way that they wanted things handled. And then actually trying to deliver, I think a lot of places I worked even, had a similar philosophy on the books, like we're going to keep your claim counts down. We're going to, it's not just about billing. We want you to push them and, do good work. And we're going to give everyone a lot of help and you're going to have all the technical resources to make that happen. But, as firms grow, it becomes increasingly harder to stay that course, and so when you went from having one-on-one assistance, the people go to 2 to 1, and um, claim counts when they were like in the 60s, and then they realized like, oh, there's some attorneys with 60 files that can't hit a profitable number of hours, so then they start giving everyone 80 and 90, and it just everything snowballs, and then the product moves away from what they started with. And that's not to say we didn't have, I mean, we've had these
Yeah.
discussions
Oh yeah.
like, should we go 2 to 1? Should we, give people more cases and, everything. But like, just, I think having the constitution to stay the course and just stick to our guns, um, it led to some years where we weren't that profitable because the people that we were working with weren't, delivering the goods. But ultimately, I think we've found like a good balance in delivering to our clients what they expect from us, and keeping our, like system flowing in a way where we can still, maintain a meager
Yeah.
profit.
Yeah. I think yeah, even as we scaled up, over the years, I agree. Like we had all those discussions, and it's hard to scale the business when you're growing and keep the boutique mentality and the way we
Yeah.
operate and stuff. And I think we did a good
Yeah.
job with that. And
Yeah.
I think that's why we've grown kind of organically,
Yeah.
over the last
Yeah.
10 years. And it's
Yeah.
been very steady. We've been
And we've
able to
always
kind of,
been willing to tell people like we can't take any files anymore.
yeah,
Like if we're swamped, I mean, I know we've done it several times now in SoCal. Like, hey, can you slow the spigot down a little bit? And people appreciate that. I think I've only had that backfire on me once, where a client slowed the spigot and never turned it back
yeah.
on. But
Well, and the biggest thing is, yeah, I'd rather have this spigot slow down a little bit than not deliver on the promise, and
exactly,
I think you feel the same way. And
yeah,
the losing some cases, if somebody doesn't start sending cases again,
yeah,
is less important than making sure that the whole of our clients are getting what they're paying for, and
exactly,
so I think that's been a big piece of it.
yeah, yep,
But no, I'm stoked, man. 10-year party, keep it going. 10 more years, 20
yeah.
more years. We're
Man,
youngsters, right?
I think I have 15 in me tops.
Oh yeah, yeah, yeah. You're a little older than me. I forgot. So, oh yeah,
Yeah.
I'll hold you to the 15 though. but
uh,
um, but we wanted to hop on this podcast. Just every month there's panel cases that come down. There was nothing horribly huge that came down in terms of en banc decisions or anything this month, but there were a few interesting panel cases that you and I were talking about
yeah,
when we saw them come down the pipe. So um, I don't know. You want me to jump on mine, or you want to jump on yours?
yeah.
We each
Just
grabbed one that we
jump
thought
on.
was interesting.
Yeah, just jump on yours.
Okay. So there's a case, Rivera versus City of Petaluma, that I thought was interesting that I wanted to talk about just briefly. Essentially, it's a case about unreasonable refusal of medical treatment, and I picked it because it's sort of an issue that doesn't come up that much, but it's an important concept that I know adjusters need to be aware of, and even attorneys that don't deal with it much. Because even over the years that I've litigated cases, I've used the labor code about 5 times. Um, and it's labor code 4056 basically says that an applicant cannot unreasonably refuse medical treatment. And if they do, they can't pursue their claim. So this case, it's a police officer. He's sitting in his patrol car in Petaluma, twists his neck, starts getting lightheaded, and finishes his shift. On his way home, he gets lightheaded again. So he goes to the hospital where they find out he has a stroke. Um, they go to a QME. The QME thinks that he might have a congenital issue in his neck called Bow-Hunter syndrome, which is like BHS, is what they use in the literature. And the QME says, well, I can't really make a determination on causation. Uh, there's a test that he can do that I can determine if he has it. It's called a DSA test, but it's sort of a risky test. There's a 5% chance that he'll sustain another stroke during the test. So applicant refuses the test. They depose the QME a bunch of times. They go to trial. The judge basically says, well, it's AOE, COE. He had an injury. He didn't have to undergo the test. So the defendant, rightfully, I think in this case, appeals it. So on recon, they did the analysis of there's 2 prongs to 4056. The employer has to be unequivocally wanting to provide the treatment, which they were in this case, obviously, and that the risk of treatment has to be inconsiderable when you compare it to the injury that you're dealing with. So the defendant in this case was saying, "Hey, this injury is a serious injury, so 5% is not that significant." Um, on appeal, the recon unit basically says, "Well, yeah, that's pretty significant, 5% to have another stroke. So it's not unreasonable to refused to do the test. However, the WCAB erred in finding injury. Uh, Even without the test, the QME has to use her best judgment and say, within a reasonable medical probability, did he sustain? Does he have this congenital issue or not? You don't need absolute certainty by a test. The QME can use their best judgment. So they kick it back down. So there was goods and bads that came from it, but in this case, the defendant lost on the issue of whether it's an unreasonable refusal of medical care, basically.
Right.
And um, I've had cases just from the ones that I've dealt with. When I was reading this, I had one that came to mind, which is a few years ago. I had a case of a guy claiming a psych injury, and he had a monstrosity of a psych PD, something like 50%. The psychiatrist, though, says the guy does not believe in psychiatric treatment, will not undergo any treatment, so he's PNS'd, and that's at 50%
Was he
PD
a
at the end of the day.
Scientologist, or what? Why didn't he believe in psych treatment?
He lived up in the woods. He was a good old boy. Didn't believe that
Okay.
that was a real deal. Going and
Okay.
seeking counseling, I guess. So I had, in that case, I used it a little differently, and I deposed the QME, and I said, well, if he didn't unreasonably refuse counseling, because in my case, sitting down and talking to somebody is certainly not a risky proposition, right? Like you're
Yeah.
not going to sustain injury, you're not going to die.
Right.
And in that case, the QME said, well, if he would go through some therapy, he would be completely fine. Basically that's what the QME said. So I
Yeah.
ended up settling that for almost nothing,
Yeah.
as opposed to 100,000 plus in
Right.
PD. But
This
um,
is a this case is tough though for the defendant because like a stroke,
yeah, it's a big
like
deal.
yeah, it's a big deal, and like how is the like it's just frustrating reading some of these cases where the doctors s- say too much,
Yeah,
like, and I get it that they have a duty to warn of risks, and I feel like they're covering their ass in some respects, but like this is clearly a test that would have given the defendant something as far as finding causation, but to say that and then I don't even see how the doctor can use his best medical judgment to say whether it's,
Yeah,
this
well,
bow
so
hunter syndrome or not.
so there was some deposition testimony in the case that they cited, and it
Hmm.
looked like the doctor was pretty convinced that that's what he had, that he had this bow hunter
Oh, okay.
syndrome. But the doctor couldn't said, well, I can't I can't diagnose him with it without this test. But
Right.
if I was to, he almost certainly has it.
Yeah.
And then the doctor said, well, and without the test, I can't really address causation well.
Hmm.
Um, and so, it can go back and forth because my guess is that when it goes back to the QME
Hmm.
and they send the QME the supplemental because the recon board pretty much gave the language that
Hmm.
uh, to send to the QME.
Right.
I the recon board said, do not issue a report based on medical certainty. It needs to be based on reasonable medical probability. It doesn't
Yeah.
have to be 100% certain.
Right.
So my guess would be that the QME is going to say that a reasonable
Yeah.
medical probability he has Bowhunter syndrome based on the circumstances,
Yeah.
and therefore it's non-industrial. That there was no
Yeah.
contribution from employment, and then this guy's going to get the test, right?
Yeah. He's gonna get the test to try to show that it isn't, but
Yeah. So it's going to flip, right? So I think that would be my guess the way this pans out. I'd be interested to know, but
yeah.
um, yeah, it just the QME was they kept asking the QME, can't you diagnose him with this? And the QME said, well,
Yeah.
I can't diagnose somebody without a test. That's how you
Yeah.
diagnose this thing.
Yeah.
Um, they might have been asking a bit of the defense attorney in the case might have been asking a little bit of the wrong questions at the
Yeah.
depot because it seems clear to me that you could have steered the doctor,
To-
to say that like, hey,
yeah.
without the test, we're not asking you for a definitive diagnosis within a
Right.
reasonable medical probability. Do
Hmm.
you believe, based on your medical experience, that he likely has this?
Right.
And he would have probably said yes, right? So
Yeah.
it might have been a bit of the fault on the defense attorney, but of course, I haven't read the whole deposition transcript, and I'm not in the know. So,
Right.
but
Right.
just my guess.
And it's easy. It's easy to Monday morning quarterback that,
Yeah, it
but
always that's the best time to quarterback.
yeah. Yeah. The fine folks at Mullen Phillippe
Yeah, I don't want somebody on a
are good.
podcast criticizing my case.
uh, so the case I wanted to talk about was Abraham Alex versus All Nation Security Service. This is a security guard that was working at a train station. Like a homeless dude walks in, starts, you know, messing stuff up, punches the security guard, and then bounces, just takes off. And then the security guard gives chase, follows him outside, and he trips and falls, cracks his head open, like concussions, all kinds of problems. So they go to trial on the issue of AOE COE. The defendants are claiming um, that their policy is to not give chase, and their policy actually for this particular person was to just check tickets. And so they tried to claim he was outside of the scope of his employment because he deviated from his actual tasks. The WCJ found that the witness testimony was credible, but determined that his deviation didn't constitute a substantial deviation to take him outside of the course of his employment. The appeals board reviewed everything, agreed with the WCJ, and denied reconsideration. So it's I mean, this is a pretty common, fact pattern, not necessarily in the homeless guy and whatever, but people doing things outside of the scope of their employment or not following the rules, and um, it kind of gives us some guidance as far as what the board is going to see as a material deviation from their job. I mean, in this case, I think, what'd you say, Jason? They found that he fell like 6 meters from the door or
Yeah,
something like that.
it was very close to the stop, and then they talked about, and these are factors in all these deviation cases, whether it's a minor or a material deviation. And
Right.
the personal comfort doctrine a lot of time comes into this because a lot of these kind of cases are involving people. They might be traveling salespeople and they stop by Home Depot to grab something for their own house on their way home,
Right.
um, or cases like that. And so there's many factors in terms of is it a personal errand, how the length of the deviation, the nature of the deviation, those kind of things. And
Right.
in this case, like you and I talked about before we hopped on here, I think it might have made a bit of a difference whether he's pursuing this suspect or this person 6 meters away from the building, or if this guy's an Olympic athlete and he had chased this homeless man for 2 or 3 miles through
Right.
traffic.
Right.
That might have swayed the court a
Mhm.
little bit, but in this case, they just didn't have it. That
Yeah.
he's performing his duties as a security guard. Um,
Yeah.
and then there was testimony, even in this case, from his direct supervisor, who referred to him as a brave individual for taking on this because the security guy was in his 60s
Yeah.
chasing this guy.
Yeah.
And they didn't discipline him because they didn't think it warranted getting written up, even.
Yeah.
Um, so it just wasn't a fact pattern for me that I thought that I would have thought they would have had a lot of
Yeah.
that would have got a lot of bite on. I mean, I not to say that if I got this case, I wouldn't deny it and try to settle it and go
Yeah.
from there. But when you go all the way to trial and it goes that far,
Yeah.
you have a sympathetic guy doing his
Yeah.
job. Yeah, I mean,
Yeah.
it's a tough one. It's a tough one to prevail on at trial, but I see why they pushed it.
Yeah. I mean, but
Yeah,
going all the way to recon,
yeah,
like
that's
at
a little
that point,
stubborn move there.
yeah, it's like
Yeah,
someone's kid needed Jordans.
yeah. That's a lot of legal fees on a case that I could have told you that it's a
Yeah.
99% chance you're going to lose a trial,
Yeah.
and that it's an almost certain chance you're going to lose at recon because it's purely
Right.
factual on all these deviation cases, and the recon court board talks about it. Unit talks about it.
Yeah.
That this is a fact pattern, and
Yeah.
they're going to rely heavily on the judge and the testimony.
Yeah.
They're not going to go
Right.
back and reevaluate the testimony of these
Mhm.
people.
Right.
Um, yeah, and you don't really have a legal argument,
Yeah. Yeah.
So it's a strange one for me to recon, but
Yeah.
hey, it's not my money.
It's it's funny being in the industry that we are, like this, like security guards giving chase and knowing that that's against policy for most security guards. Like, you see people that see these videos online where someone's getting like assaulted at like in front of a building, and there's a security guard like watching through the window, and they might like even close the door,
Yeah,
to keep the assault happening inside. And people are like, oh my God, that guy's so heartless and whatever, whatever. But he's like, that guy might get fired if he actually intervenes,
yeah,
like there's, a lot of workers' comp issues that come in, like if that guy jumps out there and does something. So like, I don't fault those guys because they're just doing their job. Like,
yeah. And,
are
uh,
they being good humans? Maybe not, but like I understand,
yeah, and,
why they
and
would
these
sit
these are
on their
all
hands.
these security guards are unarmed.
Yeah.
Um, this guy was unarmed,
Hmm.
and you're putting yourself in a situation where you can get yourself seriously hurt. I mean, they
Yeah.
they said that the homeless man was much larger than him.
Yeah.
Who knows if he's armed? He was belligerent in the train station or the bus
Yeah.
station rather. And as you and I know, we've seen a million of these security cases through the years.
Yeah.
We do a lot of that type of work, and they're always getting assaulted.
Oh
But
yeah.
every one that I've seen, yeah, the policies always say that they're not supposed to go
Yeah.
hands on with people. They're not supposed to
Yeah.
apprehend or tackle people or
Right.
chase people.
Right.
But when you just got punched in the trains in the bus station, it's kind of hard not to chase somebody after they do that
Yeah.
to you, right?
Yeah.
Um,
Yeah.
and it's important, I guess. People listening to this, most people will be thinking, well, obviously, if you got punched in the, where's the AOC theory, right? In this case, the
Yeah.
defendant actually did kind of a clever thing here, where they had all the doctors say that he wasn't injured by the punch, that all the injury came from falling outside. So that's we have to distinguish
Yeah.
that here, because
Right.
if the injury started inside this bus station, then unquestionably, obviously,
Right.
it's AOE But that was
Right.
they were able to kind of get that line in the sand drawn medically,
Yeah.
and then
Yeah.
they had this. potential defense. But
Right.
because I know
Right.
any adjusters or attorneys listening to this, they're going to be like, where's
Yeah.
that coming from, right?
Right.
But
Right.
that's how they were able to kind of do it.
I think what's going to be interesting going forward, because I think a lot of companies are moving towards like a hybrid system where people are going to work from home a lot more, even post pandemic. Like what is going to be deemed a material deviation for someone that's working from
Hmm.
home? You know what I mean? Like, is it like, because the personal comfort doctrine could apply to like literally everything they do inside their
Yeah,
house. You know what I mean? And so, how many personal comfort breaks can people have? And
yeah,
like, how do you how do you differentiate, or how do you even know, right? Like that person could get hurt going to the kitchen and say, "Oh, that was my one break today," but they could have been going to the kitchen like 20 times. Or should
right.
they be allowed to go to the kitchen 20 times? Like I think we're gonna see some cases where people are gonna have to draw a line in the sand on that issue for work from home people, because like what is material for that person? Like grabbing a snack, maybe not, but picking your kid up from school certainly seems like it would be. But what if the school's across the street? you
Yeah,
know
well, I can, yeah, you can really extend it out. I mean, because yeah, say you have a computer programmer, used to work at Google, working from home now, full time, works 6 in the morning to 5 at night. This the that's the schedule. Um, yeah, like you said, goes and picks up his kids at school, drives 2 miles back and forth at 2 o'clock. That's basically the break. Out of personal comfort, it could be. I mean, the employer's giving a lot of freedom to employees working at home to log in, log off.
Yeah.
Is it going to be like a situation where there's the business traveler portal to portal, like where anything you do
Yeah.
sort of at home,
Right.
what if you run up to 7-Eleven to get your lunch?
Yeah.
Uh, I mean, you could think of 1,000 scenarios that are kind of borderline where
Yeah.
it's like it's not ridiculous that you could claim comp, but it's
Yeah.
also obviously not AOE like within the course of
Yeah.
employment to go pick your kid up from school, bring them home,
Right.
get them on their iPads, whatever, right?
Right.
And we all know everybody's doing it,
Right.
right? So
Yeah.
so somebody's going to get in an automobile accident, something's going to
Yeah.
happen, and these
Right.
claims are going to come down, and
Yeah.
they're going to go all the way because I mean, I would. Those are the cases that I would tell the client, hey, we got to see how this is going to pan out. You can't just accept a
Yeah.
case like that. Otherwise,
Yeah.
you're going to accept every case.
Right.
And those are where that would seem like the material deviation outside the
Hmm.
scope. So yeah, I think that when half, I mean, who knows how this is going to play out, but I think there's going to be a large portion of the population that are going to continue working from home,
Yeah.
even 30%.
Yeah.
And yeah, these things are going to come up.
Yeah.
That'll be the comp case of the future. I don't know.
Yeah. Be interesting. Cool, man. I think that's all we had for today.
Yeah, it was a quick
So,
one. Yeah,
yeah,
nice seeing you, buddy.
good seeing you. Good jumping on with these things. So,
Yeah.
keep these things going. Thanks for
Yep.
listening, everybody.
All right. Talk to you
All
later.
right. Bye bye.